Preston Hennekins. I'm this year's president for FedSoc. We want to welcome you to our first event, first real event of the semester. We're going to be talking about the Second Amendment in light of the Supreme Court's decision in the prior term of United States versus Rahimi. And we are very happy to have Professor Josh Blackman here to speak to our chapter again. He was here last year and spoke about the Second Amendment, but spoke about it before the Rahimi decision. And so now I'm very happy to have him here to talk about what that jurisprudence is going to look like now that that decision has occurred. Professor Blackman is a constitutional scholar. He clerked for Judge Danny Boggs, who is on the Sixth Circuit, which obviously Kentucky's a part of.
This is the second home for me. I love Kentucky. I mean that sincerely.
And we're happy to have you here. So without further ado.
Thank you so much. Yes, it's a treat. I clerked in Louisville, right down the road. I was there yesterday, so I'm a judge. Always happy to come back here. It's a lovely place. I do like Kentucky very much. So the Second Amendment, it's sort of strange. In the span of 2 years, in 2008 and 2010, the court had two landmark Second Amendment cases. D.C. v. Heller held that the Second Amendment protects a right to bear arms inside the home. And then 2 years later, we had McDonald v. Chicago, which held that the Second Amendment is incorporated, that is, applies to the states. And so at the time, we thought, wow, we have these two big Second Amendment cases back to back. This is going to be a really important area of constitutional law. I graduated law school in 2009, and we were all just so excited about all the things the court would decide. For example, is there a right to conceal carry? Is there a right for carrying different types of arms? Does the Second Amendment protect the right to an AR-15, an extended magazine clip, right? All these sorts of questions were there. Another question, nonviolent felons, right? Can Martha Stewart own a gun, for example, right? What does the Second Amendment mean? And there was just this renaissance of articles and debates in 2010 saying, look, we have an entire open field of common law. What ended up happening? In case after case, lower courts rejected Second Amendment claims. In many regards, they resisted Heller. They said, whoa, Supreme Court, that's nice, but we don't want to change the way we're doing things. And we saw in these decisions almost open defiance of Heller, and courts read it narrowly. This is not new. Very often the case that lower courts don't like what the Supreme Court says, but usually the Supreme Court will grant review and say, no, here's what we said, and we meant what we said. But with the Second Amendment, it was different. In case after case after case after case after case after case, the court just denied cert over and over again. And starting in 2015, 14-ish, Justice Thomas started writing these dissents saying, wait a minute, what are we doing here, right? We have the Second Amendment, we have this landmark case. Why aren't we taking more cases to clarify it? In the First Amendment context, we decide cases all the time. In the Fourth Amendment context, but what about the Second Amendment? And then Scalia started joining him. But as we all know, Justice Scalia died in February of 2016. And at that point, it kind of became unclear, what is the future of the Second Amendment? You didn't have anything after McDonald, and the conservative majority may be up in flux. As we all know, Trump won the election, and he appointed Justice Gorsuch. Still, no Second Amendment cases were granted that year. In 2018, he appointed Justice Brett Kavanaugh. Still, no big Second Amendment cases. Finally, the court had a gun case from New York. New York had this crazy law, and I'm not saying crazy because I don't like it, just doesn't make a lot of sense, that if you want to bring a gun to a firing range, you need to have a special type of a permit, even to keep the gun locked in your trunk as you drive to a range. And this law was challenged, and it was completely irrational, right? To keep it locked in your trunk while you're driving to a range. But what happened was kind of funny. After the Supreme Court granted review, New York changed direction. New York defended the law in the lower court, said, oh, this is a perfectly valid law. The lower courts upheld it. What did New York City do? They repealed the law. And they didn't just repeal the law. They had the New York legislature pass a bill which prohibited the reenactment of the law. Have you learned about mootness in Civ Pro or Fed courts? Mootness? They mooted this case to death, right? They made it, Supreme Court, please, please, please don't decide a gun case. We don't want you to decide anything, right? They were just afraid of this case. And the court by a majority said, okay, we get it. You mooted the case. And be clear, you're messing with our jurisdiction. The reason why they mooted the case was the Supreme Court was going to reverse and declare the law unconstitutional. But yet Justice Thomas saying, this is not moot. And oh, by the way, you are evading our court's review. This is not a good practice for jurisdictions to repeal laws when they're about to be declared unconstitutional. But anyway, that was a case decided involving New York, and everyone took a sigh of relief. Then we have Justice Barrett is confirmed in 2020. And now you have not 5 conservatives-ish, you have 6 conservatives-ish. I say ish because I'm not exactly sure. But you have at least 6 Republican appointees on the court. So what happens? Another case is brought in New York involving New York's carry regime. Okay, many states, I think like Kentucky, have what's called constitutional carry, right? Where you don't even need a permit. You can just carry as a right being a citizen. Can you carry on campus here? No, you can't. Texas, you can. Goals, right? Hashtag, right? So New York had a law regarding carry that was known as may issue. May issue. What does that mean? Assuming you pass the background check and everything else, it's discretionary. The government must decide if you have a special need or a special justification to have a firearm, right? It's not enough to say, oh, I want to defend myself, or I live in a high crime area. You have to have a special need that goes above and beyond what the average citizen has. Now, to be very clear, there's a lot of favoritism with this regime. If you're friends with the sheriff, or you're a politician, by the way, when last night the vice president said she had a gun, I wonder how she got a permit. I wonder because, California had very strict gun laws. Just put that aside for a moment, right? That's news to me. But generally, politicians and favored people got guns. And if you were a regular person who lives in a very dangerous neighborhood, good luck. You do not have a carry permit. Okay, so a challenge was brought in New York by Brendan Koch and Robert Nash and the New York State Rifle and Pistol Association, saying that this is unconstitutional. All of the lower courts upheld it, and they had this intermediate scrutiny where they say, well, you can have a gun, but the government has discretion who gets it. There's not really any reason to deny the government this power. And it goes to the Supreme Court. And this case is decided in June of 2022. This is probably the most intense Supreme Court month in my lifetime. Because remember what happens, right? There was a leak of the Dobbs opinion. There was an assassination attempt on Justice Kavanaugh's life. And then in the span of 96 hours, we get Dobbs overruling Roe v. Wade. We get the Bruen decision on the Second Amendment. And we get Kennedy v. Bremerton, which overruled the Lemon test. In my life, I've never seen something that quick. Boom, boom, boom. It was just an intense. I was actually in Kentucky when it happened. I was at Judge Boggs' clerk reunion, staying until 3 a.m. blogging about it. But that was a very contentious period. So when you think about these cases, a lot was happening at the court, and because of the assassination attempt and the leak and all these security measures, they weren't talking to each other. And I've become convinced that had this been a normal term, Bruen may not have been what it was. I think it may have fractured. So what actually happened in Bruen? So the first tell that something was off was that Justice Thomas wrote the majority opinion. He has never assigned majority opinions of any significance because he is not particularly keen on, compromising. He likes to write his opinion, and if people don't want to join it, well, that's too bad for them. By contrast, Justice Roberts or Justice Kavanaugh, what they call hold 5. They will hold the majority together. Justice Thomas said, when we're deciding Second Amendment cases, we have to look to history and tradition. And he used something called analogical reasoning. Remember this from the LSAT? Right? If A is to B, then C is to D. Remember we did this one in the LSAT? Maybe it's getting rid of it now. I don't remember. And what Thomas said is, if you want to have a law with this may issue regime, you have to find some sort of historical analog that supports it. Okay, so what were the historical analogs? Well, there were some laws going back to the Statute of Northampton in the 1300s, which said that you cannot go armed dangerously armed in the woods. I'm paraphrasing it, right? And New York says, aha, see, it says you can't be armed outside in public. And then the other side said, no. It says you can't be armed in a dangerous fashion. That is, brandishment or scaring people. A concealed weapon people can't see doesn't cause that sort of fear. And the New York says, no. Per se, by definition, having a gun was dangerous, right? Because it's a dangerous weapon. And the majority by Justice Thomas said, no, that's not enough, right? You can't extrapolate from a ban on carrying dangerous arms to a absolute ban unless you pass the government's discretion. And that's too much. There was another type of law that was at issue called surety laws. This is a surety law. It's basically a bond. That is, if a person was viewed as someone who was dangerous, that person had to post a cash bond and usually get a witness, a character witness to vouch for them. And the thinking was, if this person ended up doing something bad, he would surrender the bond. So there was a penalty in place to keep people behaved. There wasn't really a police force the way you would think about it today. That didn't really exist back in the back in the day. But you had these surety laws to try to get around it. And so Justice Thomas says, is a surety law similar enough to this Mayish regime? He says, no. At least with a surety law, if you paid a amount of money, you got to carry your gun. Here, it's at the government's discretion. So that analogy is not close enough. So at the sort of big picture, the vote in Bruin was 6-3, but it wasn't really 6-3. Justice Kavanaugh and Roberts wrote a concurrence, right? They wrote a concurrence. And it was kind of a unusual concurrence. He said, yes, we agree with the majority, but here's some limits on it. And that's when we know there's a problem, right? If they agree with the majority, they agree with the majority. Let's find some limits on the majority. So Kavanaugh wrote that states can require applicants to satisfy background checks, firearm trainings, and mental health records check. Mental health records check. That wasn't an issue in the case. There was nothing about mental health in the case. But we know that Justice Kavanaugh was almost assassinated by a crazy person, right? So he was thinking about keeping guns away from crazy people. That was what was on his mind. Sorry, crazy people is not the right choice of word, but that's probably how he would describe it. By the way, that case involving Justice Kavanaugh's assassination is probably going to trial next year. The defendant didn't plead out. So there'll be a trial next year on the attempted assassination of Justice Kavanaugh. Kavanaugh also repeated certain limitations from Heller, that long-standing prohibitions on firearms are valid for the felons and the mentally ill. And you can't carry in sensitive places, for example, schools, I guess. So the Kavanaugh opinion sort of kicked in. Dean Salamanca, my dear friend. Do you know he's the dean? They let him be the dean. Did you know this? I think there must have been some sort of, voting machine was hacked in Venezuela or something. I don't know how this happened, but thank you, sir, for coming. But anyway, the majority was undermined by the Kavanaugh-Roberts concurrence. And then you had Justice Barrett, who's, I've been critical of her. She's a law professor. I know how law professors think, and law professors should not be judges. I believe that sincerely. We have a different role in the world. They shouldn't be presidents either. Think about that one, right? Barrett made this stink about we shouldn't be looking at stuff that happens after ratification, right? In other words, the meaning of the text is fixed in 1791. Why are we looking at the practice in the 19th century? And I'm sort of sympathetic to that argument, but it didn't really make a difference in Bruin because the history was the same either way. Okay, so what happened after Bruin? Again, you had the three-peat. You had Dobbs, Bruin, and Kennedy in like a 3-day span. It was like the craziest 3 days of my life. It wasn't 3 days, but it was a couple days. So the lower courts start getting challenges to gun cases under Section 922G. 922G, I hope you don't know about it. If you do, maybe you're in the wrong spot. Says if you are a felon and have various criminal activity, you are a disqualified person. That is, you cannot have a firearm. Okay, and there are lots of categories of different types of felonies, domestic violence, and so on. There's one category involving not a conviction, but if you're subject to a DVRO, hopefully you don't know what that is. If you do, that's bad. A DVRO is a domestic violence restraining order, DVRO. This is often issued by judges, sometimes ex parte, that's without the party is even present, where they say, aha, we think that so-and-so poses a threat to his girlfriend or his wife, whatever else, and we're going to issue a restraining order that you can't go within X feet of this person. If you do, you get arrested immediately. They often also force persons to surrender their arms. But on top of any state restraining order, there's a collateral consequence under federal law. That is, if you're subject to a DVRO, you are a disqualified person. You cannot hold a firearm under federal law. And if you do, it's a felony with a significant jail sentence attached to it. All right? So we have Mr. Zaki Rahimi. Not a good dude, if you want to look at him, right? Rahimi has a problem. He likes to shoot people. Not hit them, though, which is the oddest part. He fired his gun a lot. He didn't hit anyone, which is just, maybe it's bad aim. I don't know. But it's not funny. But he shoots a lot of people. So he had a girlfriend, and he beat her up. And he was very, very bad to her. And a court enters a DVRO. Did Rahimi surrender his firearm? Of course he didn't. And then he went up and he shot up a Whataburger, a burger place in Texas. And, he shot at his girlfriend. He shot at someone else. He shoots at lots of people. He doesn't hit anyone. Now, you think the police would arrest him on attempted murder or some sort of actual claim. But the police don't actually arrest him. Why? That's a failing in this issue, right? In other words, if you are this much of a danger to people around you, why the heck are you not in jail? Why the heck are you not in prison? Lock him up, right? Lock Rahimi up. Lock him up. Seriously, right? He should not be among us walking in the streets. He's just too dangerous. He's shown himself again and again as trying to shoot people, right? Having a restraining order obviously didn't cabin him. But for whatever reason, the good people in Northern District of Texas didn't actually lock him up. Instead, they only issued this restraining order, which he promptly ignored. Rahimi was later convicted under 922G of being a felon in possession of a felon, but a disqualified person in possession of a firearm. And he was found guilty, which he did. Then Bruin comes along and he asks for the court to sort of reconsider his conviction in light of Bruin. Now, there are other cases involving felons. My favorite case is Mr. Range from the Third Circuit, I think from Pennsylvania. He engaged in food stamp fraud. He lied on an application for food stamp as income. Okay, it's a felony. I don't want to diminish it. If you lie on a federal document, that's a felony. But come on, right? Lying in an application because you need more food stamps, does that result in a lifetime bar of owning a firearm? Does anyone think that's a just result? If you don't like guns, right? If you hate guns, he lied on a food stamp, wasn't the most educated person. We don't know his intent. So the Third Circuit held in an en banc decision that you could not disarm a person for life for a nonviolent felony, that there's no tradition to support that. There was a similar case from the Seventh Circuit called Cantor, Kanter, and actually Judge Barrett was on that panel. And Cantor involved a guy who engaged in Medicaid fraud. Okay, so Medicaid fraud is worse than food stamp fraud. He apparently ripped off the government and he submitted some false claims to the U.S. government. Bad stuff. He had these, I think they were insoles for shoes for medical reasons, whatever. It doesn't matter. But he was disarmed. The majority said, yes, you are a felon. Doesn't matter if you're violent or not. You can't have a gun. And Judge Barrett said, no, this is insane. There's no tradition of disarming not dangerous people. So of all the cases to go to the Supreme Court, which one did I want to go first? I wanted the food stamp guy to go to the court first, right? That was the case I wanted. But then the Fifth Circuit said, hold my beer. My beloved Fifth Circuit. I love my Fifth Circuit. I love my judges there. They're wonderful. But they faithfully apply precedent. They do so very quickly. So the first case out of the box after the Bruin decision was Rahimi. And the panel of the Fifth Circuit, including my dear friend Judge Ho, ruled that there is no tradition of depriving of arms simply because of a restraining order. You have to have a conviction, right? Unless you have a conviction, you cannot deprive the person of the right to bear arms. So the Solicitor General is the opposite of me. She doesn't want the food stamp guy to go up first. She wants the guy shooting up Whataburger, right? That's the one that she wants. And I'm not kidding you. The government filed a cert petition like in 2 weeks. Usually it takes them like 90 days, make an extension. No, they rushed this in because they wanted this to be the first case in the pipeline. I mean, it's genius, right? I mean, so much of Supreme Court practice is timing. And there's an art to it. And the government, the SG is just the master because they know everything about these tips. So the SG puts up the cert petition to Rahimi, and the court, of course, has to grant it, right? And at the time, I'm like, okay, they're going to reverse. But reversing it is tricky. If you actually read the Fifth Circuit's opinion in Rahimi, and I mean this, Judge Ho got it right. He faithfully applied Rahimi. He faithfully applied the Bruin standard. Bruin says you look for a historical analog. There is no historical analog to support depriving someone of arms based on restraining order. If there's a conviction, yes, but you need to be actually convicted by a jury of your peers. So in order for the Fifth Circuit to be reversed, the court would have to, as they say, walk back. The court would have to walk back the Bruin standard. And that's exactly what they were going to do. Right? In no universe would Justices Barrett and Kavanaugh in particular allow a domestic abuse person to keep a gun. That ain't happening, as we say in the law, right? That was not going to happen. The question was how they got there. So the opinion was assigned by Chief Justice Roberts to, well, himself. He gave himself the majority opinion. And this was an 8-1 vote. It was 8-1, maybe 7-2, but I call it 8-1. 8-1 vote, I'll explain why. And Roberts wrote the majority opinion. He did not repudiate Bruin. In fact, he stood by the decision. But you might say he clarified Bruin. He explained, here's how we're going to interpret Bruin. Who was the one dissent? It was Justice Thomas, the author of Bruin. So you might say, wait a minute, who is a better guide of what Bruin means? The guy who wrote the majority opinion or the guy who wrote a concurrence that limited it? Frankly, it doesn't matter. Because of the court, with 5 votes, you can do whatever the heck you want. And with 8, you can really do what you want. So the court sort of modified the Bruin standard. And the most famous line from the Chief Justice is basically a paraphrase of Jurassic Park. The law is not trapped in amber, right? Remember the whole fossils of the mosquitoes in the amber, right? My kids love that movie. Robert says you don't need a perfect historical analog. Close enough is good enough. So how did Roberts get to a historical support for the DVRO, the felon disenfranchisement, the domestic violence restraining order disenfranchisement? He said, well, we have 2 types of laws. The first law I mentioned is the surety laws. It said if you were dangerous, you have to post this bond. If you did something bad, you surrender. So that shows the government can take action before a bad thing happens. And you also have felon disenfranchisement, which says if you're a felon, you lost your arms. What did Roberts do? He glommed these 2 things together. He combined them. He said, well, the government can take action before something bad happens, and after something bad happens, take your gun away. So let's just combine them to say they can take away your gun before you do something bad, right? They can take away your gun before you do anything bad, before you're convicted. And Justice Thomas is like, throwing it's like, what? That's not what we said. You guys are playing the trick, right? John Roberts is a master magician. It's misdirection. He's like, look there, but it's really going over here. Right? He's always telling you to look the opposite direction. Look at Obamacare, for example, right? It's always misdirection. And Roberts is such a good writer. Oh, man, if you want to see the best writer in the court, it's Roberts by a mile. Scalia was number 1. Now it's Roberts by a mile. Kagan can be second sometimes. Barrett maybe a close third. And after that, they'll fall off. But Roberts is some are pretty not very good. Roberts, the trick is when a justice is writing consistent year to year, it's not the clerks, it's him. And when a justice is writing varies year to year, it's the clerks. That's the tell. You can actually do studies on how justice uses word choice from year to year to year, and those are the biggest variability relied the most on the clerks. Like a Scalia opinion, year to year was basically the same. A Roberts opinion, it's the same. Other judges, not so much. Anyway, the Roberts opinion combined, and Justice Thomas, like, what are we doing here, right? This is not a faithful application of Bruin. If you do faithful application of Bruin, then the Rahimi conviction, the Rahimi sentence must be reversed. But Justice Thomas was alone in dissent. The closest to Justice Thomas was Justice Gorsuch, and this is still 3 months later. I don't think I fully understand the Gorsuch opinion. I'll try to explain it, but I don't think I'll do a good job. You learn about in federal courts the difference between a facial challenge and an as-applied challenge, right? You've learned this? Okay, so a facial, Mr. Fed courts over here, right? A facial challenge means you challenge a statute. Yeah. A facial challenge means you challenge a statute literally on its face. That in all regards, in every facet, this is an unconstitutional statute. It's a very high burden for good reason. You have to show in no circumstance will this statute be constitutionally applied. There's a case called Salerno from the 80s that established this standard. An as-applied challenge is very different. It says, well, the government's enforcing this law against me in these regards, and I just want an injunction to stop this specific thing they're doing, right? It's a narrow relief. Whereas a facial challenge, in theory, they're basically invalidating the statute top and bottom, root and branch. It's gone. What's curious, and this still is very hazy to me, in a criminal conviction, Rahimi was saying this statute's unconstitutional. Is that an as-applied challenge, or is that a facial challenge? Now, the only thing Rahimi cares about is get me out of jail, right? That's all he cares about. So in my view, it's really an as-applied challenge, but the doctrine that's developed is when you're a criminal defendant seeking to dismiss an indictment, it's a facial challenge. So you have to show that not only is the statute unconstitutional as applied to me, it's unconstitutional as applied to everybody else. And I've actually talked to the person who represented Rahimi. He's a federal defender in Texas, really nice guy. And he said this is basically a mess, that the courts don't really understand this doctrine. So Gorsuch comes out and says in a concurrence, well, because this is a facial challenge, he doesn't meet the standard. But maybe if it was as applied, it'd be different. So it's a dodge. He didn't want to be in favor of ruling in favor of the wife beater or the girlfriend beater, right? He didn't do that. It was a dodge. I suppose someone can bring a civil action after they get out of jail seeking restoration of their gun rights, in which case it would be as applied. That'd be the vehicle to do it. But that doesn't help Rahimi here. So again, the vote was 8-1, although Gorsuch signaled that in a different vehicle he might be willing to rule in favor of a defendant. He probably would prefer the food stamp guy, not the shooting up Whataburger guy, but that's how it is. And then we have Justice Kavanaugh. He's a curious judge. He is very much intent on focusing on what he calls tradition. So we always hear text, history, and tradition. Okay, text, I get, right? What does bear arms mean, right? There's a word we find its meaning. Text is easy. History, I get, right? What were the types of gun control laws that were in existence before the Constitution was ratified? There weren't many, but there were some. But tradition is not looking backwards. Tradition is looking forwards after ratification. That is, what were the gun control laws passed in the 1800s? In the 1900s, maybe, right? Who knows how far to go? Justice Kavanaugh wrote this very long, way too long in my view, concurrence, repetitive to the end of the world. He wrote this long concurrence saying, here's how we do tradition, right? We look forward, we try to figure out, is there some practice that's so continuous that sort of informs the original meaning? Then Justice Barrett, who I actually agree with in large part in this case, at least this part, says to Kavanaugh, what are you doing, Brett? What's going on here, right? We are originalists here. We're not traditionalists, right? We're originalists. Why do we care what happens 100 years after ratification? She made the same point in Bruin a couple of years ago. And this fracture appeared in several cases last term, including Vidal v. Elster. It was an IP case, but Thomas and Barrett had a spat about how to do originalism. So there is an open revolt among the three Trump judges, Gorsuch, Barrett, and Kavanaugh, about how to even do originalism. They agree they're originalists. They just don't agree what that even means. So they say, oh, this MAGA court, I wish. They don't agree with each other. Right? These three judges are just as likely to vote with the liberals as the conservatives in any given case. Right? So Barrett, again, how do we describe her? She's an originalist, and I believe that. I think she firmly is. But Justice Barrett is also, as we say, cautious, hesitant, tentative, right? Whenever you're in class, and the person says, oh, that's a nice idea. Do you have a theory to back it up? You've heard this. You back it up. That's Barrett. When she gets an originalist argument, she wants an entire theory, like a book, to explain every facet of it to her. And if she can't be persuaded you have a theory, she rules against you. The upshot is the government wins, right? The status quo remains. And Barrett becomes just a common law judge, like a John Marshall Harlan, just very Harlan II, just very restrained. So she's very curious. People don't get her. I think I get her. Maybe I don't. But she's very smart, brilliant, I think. Probably the third best writer in the court. She writes, her approach is just very, I don't know what we're going to do here. We got to just be very cautious. We have to tread lightly. If you think of it in terms of gun, the topic of our debate today, very heavy trigger weight. She needs a lot of pressure to pull that trigger before she goes, right? Dobbs, she said, okay, I'm going to pull the trigger here. Kennedy v. Bremerton, she pulled the trigger. But in Rahimi, she was like, can't do it. Okay? You had a dissent. I'm sorry, by Justice Thomas. And again, Justice Thomas is probably the most conservative justice in modern American history. I'm not exaggerating too much by saying that. And Justice Thomas is almost exasperating. Where were you guys 2 years ago? You joined my opinion. What happened? I think the short answer is they may have joined the opinion, but they weren't actually on board. This was a contentious term. You had abortion, you had religion. They may have actually tried to flip that majority, but they couldn't, right? Because things were going on so quickly that they kind of just let that one go and said, okay, we'll deal with it later. All right. So Rahimi, meeny, miny, mo, the Second Amendment's got to go, as they say. In the aftermath of Rahimi, I had some hope that the court would grant review in the range cases. Again, this is the food stamp case from the Third Circuit. What did the court do? They vacated the favorable en banc opinion range and sent it back down to lower court. Say, here, consider this in light of Rahimi, and it will go back up. So now you have all these other cases that were actually somewhat favorable. They're getting vacated in light of Rahimi. So Bruin had a good run, 2 years. It was awesome, right? Good while it lasted. Party. But it's almost more or less becoming scaled back. We have decisions now from the Fourth Circuit that have held basically a ban on AR-15s. Right? Decision from the Ninth Circuit saying, yes, you can ban carry in public parks and public transportation. Unless the court intervenes and starts to take more gun cases, I don't know how much vitality Bruin actually will have at the end of the day. I think that this is a precedent that existed in a moment that was very unique on the court. I think a lot of them have come to regret it. So Justice Thomas's analogical reasoning, I think, has been sort of scaled back. Chief Justice Roberts, well, just sort of look to history-ish and just mix stuff around and it'll be close enough. That's probably the new standard. So I feel like I give this talk at UK almost every year. I was super optimistic 2 years ago and not feeling so optimistic right now. All right, I'll pause here and welcome your questions. Thank you so much. Yes, sir. All right, so let me just take a step backwards, right? This case could have been litigated on several different grounds. One of the grounds is the Second Amendment. That is, does depriving someone of the right to bear arms, does depriving a subject of this order violate the right to bear arms, okay? Another possible ground is the due process clause. Very often under state law, these sorts of proceedings, these DVRO proceedings, are ex parte, as people are not even present. They may not have counsel present, and they're basically losing a civil right without having any sort of process available. It could have been argued that this violated the due process rights of Mr. Rahimi. That argument was not raised. And as you all know, if an argument is not raised, it is waived. So Thomas said perhaps in another case you can challenge a DVRO on the due process grounds. That didn't help him here. But I think that should actually be a future case. Sound great till you actually start looking into them. Courts are allowed to basically take away a person's gun based on basic suspicion that they might be dangerous. Not that they made threats or hurt anyone, but that people are just nervous. I think there's serious due process problems with these laws beyond the Second Amendment issues. But this will definitely come back up. Thank you for the question. Further question? Yes, in the back.
Someone who hadn't necessarily been convicted of gun violations, but had training where that limited their ability to carry a gun, then being charged with another crime and having a similar statute. Yeah. What about pre-sentencing reports where they have open conduct and prior criminal activity, but they weren't necessarily convicted or even acquitted? Why would you make an exception for violation of limitation having a gun versus other relevant conduct? What would you?
Yeah. Have you clerked recently, worked for a judge prosecutor recently?
I have.
Yeah.
So if you couldn't hear the question, I'll repeat it. When you are doing a criminal sentencing, you should get what's called a PSR, pre-sentencing report, which is put by the probation office or someone else. And the report lists all the person's bad behavior in the past, but not just stuff which they were convicted of. It also might include stuff they were acquitted of, perhaps, or even non-charged conduct. And the judge, when they're sort of issuing a sentence, can consider, right, can consider that past conduct. That's considered permissible. I think the upshot is there's a conviction. And when you have a conviction, you serve some time. Mr. Rahimi served time for his past offenses, and there was no new conviction. So I do think there's a little bit of a difference. But the upshot is we're not just talking about any sort of civil right. It's one that's actually in the Constitution, at least some people think it is. And so when you have a court disarming people or a government disarming people, there's some sort of heightened standard to get there. That's how I would answer your question. Very good question. Other questions you have? Yes, sir. I remember you. Yeah.
I remember you too. Kamala Harris is on record routinely saying that she advocates assault with family and mandatory buyback and also similar things along those lines. Do you think the constitutional status of her willingness to take action along those lines if she has taken power so?
Right. So you are all probably not old enough to remember this, but during the late 90s, early 2000s, there was an assault weapons ban, a federal assault weapons ban, where you could not purchase an AR-15. That expired during the W. Bush administration, it sunsetted, and it was not renewed. There were no meaningful challenges to it at the time because the Second Amendment didn't have any teeth. The Fourth Circuit had a recent decision saying that the government can ban AR-15s. They call them these weapons of war. I mean, look, there are millions of AR-15s in circulation today, millions. And to be sure, a very small number of them are used in crimes. It's a tiny, tiny fraction. We're talking infinitesimally small fraction. A commonly held weapon that is used in a very, 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 very small percentage of crimes would seem to be something that the Second Amendment ought to protect. I don't know where Justice Barrett is in this issue, unfortunately. I think Justice Kavanaugh will be solid because he voted in favor of this in the D.C. Circuit. And I don't know where the Chief Justice, he might say, oh, wow, I saw a school shooting last week. That's really bad. We can't have this anymore. So I realize this is crass, but you have to sort of think about it in these terms. I don't know if there's a political will to actually have an AR-15 ban nationwide. So even assuming the filibuster is eliminated, I still think there's some blue state Democrats who have a very tough time with that vote. You do have statewide bans, but again, those are in blue states where it doesn't matter as much. I don't know how the court would treat an AR-15 ban. And it won't be a ban. What they'll do is they'll just prevent the sale of new ones. They'll just, death by 1,000 cuts. They say, oh, you can't buy new ones. And oh, you have to register the ones you have. Oh, in 10 years, okay, never register. We'll take it away from you. Thank you very much. It's always that sort of progression. So it wouldn't be an all at once. We'll just confiscate your guns. That despite whatever Trump said last night, that's probably not going to happen. But it's done incrementally. In every civilization, registration is the first step towards confiscation. It happens in every civilization in history. Oh yeah, I'm sorry, the back. Yes, go ahead.
Okay. Yeah, so I was reading the case in question today, and like this guy, he shot up a Whataburger, he followed a truck, he shot someone's home. Yeah. He fired his gun off in a restaurant, his car getting in line, and he'll shot a restaurant for owning the gun. Is there some sort of reason that he was never charged for all this violence?
I don't know. I tried to find out the answer to your question. I have no idea. This guy should be in jail. They don't think this guy should be out in the streets. Anyone? Maybe. He should be in jail for the rest of his life. I don't know. I really don't know. Especially with the criminal background, I think he should be locked up. There is a movement to perhaps decrease incarceration. Maybe this is a guy that everyone should be incarcerated. So I don't know. Yes.
So in Garland v. Cargill, where they start to talk about the Las Vegas changes and the Senate changes, where if you walk into that, usually is in reference to the machine gun. And I'm just wondering, would justices do that in your opinion? Are they trying to make just a point to stand on that's already been reiterated a couple of times, or do you think that they are trying to prepare something we talk about?
Well, it's funny. One line that walks like a duck, quacks like a duck. It's a duck. There's also the duck-billed platypus. If you actually Google it, it looks like a duck. It kind of walks. Anyway, I wrote a post about this. People were not happy when I wrote that. I think that the justices, again, Cargill was not a Second Amendment case. For those who haven't read it, I appreciate you guys reading cases. This involved what's called a bump stock. Okay, what's a bump stock? A bump stock is a device you put on the end of a gun and you sort of lean it against your shoulder. Okay, and when you pull the trigger once, the gun will usually recoil backwards. But the bump stock sort of recoils it forward, so it's a device that they use the energy to channel it. And then it comes back again. And every time it goes back and forth, it hits your finger, resulting in many bullets flying out one after the other. So you described this like a machine gun. That's what the dissenters thought it was like. But the majority said, no, each time there's one function of the trigger, a bullet comes out, so it's not a machine gun. I think this is actually, a question of statutory interpretation. It wasn't really a gun case. But to be sure, the background of this is actually President Trump favored this regulation after a mass shooting in Las Vegas where this guy stood up in a hotel balcony shooting at people at a festival blow. If you remember this one, with a bump stock, Trump's like, okay, we need to ban this. So this is not limited to Republicans or Democrats. All politicians have this inclination. And I have to think, at least at some level, the dissenters were troubled by having these sorts of guns. Now, there's another case this term that I'm involved with called Vanderstock, Garland v. Vanderstock. And this involves called the frame or receiver rule. You may not know this, but until fairly recently, if you made a gun at home, feds had no interest in it. If you sold it, it was a problem. If you had a gun at home that you made, this was not a problem. You didn't have a serial number or anything. If you bought a gun kit online, you made the gun yourself, there's no problem. The Biden administration tried to change that. They tried to say that if you have a homemade firearm, it's considered a gun, and you have to go through certain background checks to get the kit. I'm one of the lawyers in this case, so I do have an opinion on it. But I think Garland, v. Cargill, and Vanderstock v. Garland are similar in that they're trying to use existing statutory regimes to try to regulate new gun types. And I think the short answer is if you want to regulate new guns, you got to pass a statute. And to the question before, unlikely those we passed. So not sure if I answered your question, but thank you. Okay, what other questions you'll have? Yes, ma'am.
There have been for a minute and a half quite a bit of ruckus about 3D printed guns. What is the status of that?
All right, so I've been litigating the 3D gun issue for about a decade now. I started on the 3D printed gun issue in 2014, and we're now in, 2024, so it's been about a decade. Several states have passed laws that regulate 3D guns. They do this in a couple ways. One is you can't possess a firearm that's made of plastic, and that one no one really objects to. Others say that you can't print a 3D gun, which are perhaps more problematic because you can actually make a 3D gun with metal parts, so it's detectable. But in my view, the one I've worked on the most is you can't even share a file that can use a 3D printed gun. They're actually restricting the sharing of information. And I've long argued this violates the First Amendment, that there's lots of information we share that may be used for dangerous ends, and you can't ban it. The courts have not given a clear ruling upon this. I've had 3 trips to the Fifth Circuit and now another trip to the Third Circuit on this issue without a clean ruling. So the answer is it's in flux. But the 3D printed guns, right, it's a boogeyman. If you actually want to use a gun to hurt someone, you'll just buy one on the street. It's not practical to actually make these guns. They're actually very expensive. They're fragile. It's cheaper just to buy a used gun. That's a short answer. Okay. What other questions? Yes, sir.
I don't know if you've kept up with the United States v. Williams, at least in the Sixth Circuit, sitting that table down 2 weeks ago.
Remind me?
It was U.S. v. Williams, it was Sixth Circuit 2 weeks ago, about a guy who was pulled over. The cops did a weed test with a dog on his car, kind of he was a convicted felon years ago with a violent driver, but not say non-violent stop for traffic violations. But anyway, long story short with that case, several of the prior convictions, some of the more violent convictions, were plea bargains. And I was wondering how you see kind of the intersection with plea bargaining and how prevalent it is, and how it's going to prevent a lot of these non-violent felons who might have been non-violent.
Oh, so the plea bargain to do the rights.
Yeah, right, kind of, and then, as courts may work their way towards giving those rights back.
Yeah, you need to let a conviction. Yeah. I had thought about that. I'll take a look at it.
Yeah.
All right, and with that,
Thank you all so much.
Thank you, Professor Black.
Thank you.